have from my right Honorable Chinda Fobi, SDF Member of Parliament from Mezam West. Am I right?
Bamenda Bali.
Bamenda Bali. That's the name it has. Okay. We have Barrister Ernest Baka. He's barrister at law. There's also Barrister Calvin Ta Dango. It's barrister at law. And Eugene Fongwa. He's a journalist, but an economic development expert, right?
International development.
Okay, international development. Cameroon inclusive, anyway.
Yeah.
Okay. I'd like us to begin with our press review and what the papers were writing on this week. There was much also, and the late news that came in about the death of the publisher of the Post newspaper, Francis Watcher. Too late for the papers to catch up with, but all the same, Emmanuel Vemu put together the press review.
The bill on the General Code of Regional and Local Authorities passed in Parliament got press men and women reporting. Cameroon Tribune sees a turning point in the life of the country, but more so, a new era for local and urban councils as MPs vote for decentralization. But the Horizon questions bill to fast-track decentralization Bia's new pact with Cameroonians. To the Post newspaper, which presents a new look, the special status content is a poisoned gift with attractive features. Municipal updates differ with this thought and presents President Paul Bia's renewed touch on Northwest-Southwest as special, publishing innovations of what he terms historic bill. Cameroon Insider headlines, special status for Northwest-Southwest is here. The Guardian Post quotes Kumba government delegate Victor Nkelengo. Bia has given Anglophones most of what they want. Yet in the voice of the CPDM MP for Bambutos, Honorable David Mafue, Anglophones do not deserve special status, as reported by the Post Weekender. The paper further questions, after special status content, what political fate for Ndumu, Mutanga, Ngo, all government delegates of Bamenda, Limbe, and Kumba city councils? This as Chief Tabetando celebrates Decentralization Code Bill, which according to him gives councils unlimited powers as reported by the English daily, The Guardian Post. At the time, gains of special status to Northwest-Southwest regions are being examined on Cameroon Tribune. Hearings for the pre-electoral litigations by the Constitutional Council and the Administrative Bench of the Court for the February 2022 elections flood newspaper columns. Cameroon Tribune presents the verdict from the 55 complaints received in the Constitutional Council. To the Post, SDF, CDU, ANDP, PRCN form coalition to oust CPDM at 2020 elections. The Guardian Post feeds its readers with the disqualification of Boyo CPDM parliamentarian list by the Constitutional Council. To the Observer, the UDP sails through validation exercise. At the time, 9 U.S. representatives write to Bia over bloody Anglophone conflicts, as reported by the Voice newspaper. The Horizon writes, 9 members of U.S. Congress tell Bia demonstrate political will by engaging in Swiss-led facilitation process. The Guardian Post reports that the National Rights Commission is pressing government to speedily implement dialogue proposals. Yet the Observer presents Amba versus SDF battle. It terms the reality of people power. This as Mbandam and Mionjong Donatus go homeless with Amba boys burning their residence for running for February 9, 2020 elections. But Frundi cautions opposition. If we boycott elections, Bia, his satellite, will grab everything. The protests of PhD holders for not being recruited. The promise by Atanganakuna to refund 1 billion CFA francs in exchange of his freedom while in court. The state burial given to Mayor Ekema. The cry by the PCC moderator that the church has become a place for character assassination. The indictment of Limbe City Council by Konak over missing 9 billion CFA francs, and the daylight armed robbery in Cathedral at the heart of Yaoundé taking away boxes of money also form stories reported by the papers this week. News of the death of Francis Watcher came late on Friday for papers to comment on. Certainly they will pay him tribute in the coming days. As publisher of the Post newspaper, he gave us inspiration on Press Hour. We now end our press review with this call for wisdom, a write-up on the Post weekend titled Girls Be Aware of December, Bush Followers, Experts in Fake Marriages, Broken Relationships. According to Andrew Nsosuka of the Post newspaper, this is the month when love stories go sour for some unfortunate lovers. He says in this period, those who traffic in love make sudden changes, reshuffling their love cabinet by prioritizing seasonal lovers to their broke partners, often for quick monetary gains. Girls are thus called upon to remain wise and not fall victim. Until I come your way again, Merry Christmas in advance to all of you fans of Press Hour.
Okay, we would like to say send condolences to the family of our colleague, Francis Watcher, publisher of the Post. Like the reviewer said, the news of his death came late on Friday afternoon, too late for the papers to pick on. Eugene, you've known him for quite some time.
Yes, for a long time, and he was such a fine journalist. In spite of the fact that he became mayor of Kor, he continued to be a leading figure in the media. And what we will miss most were the quality of writing that he produced. He's one of those journalists who was not shy about expressing himself and showing the quality of language that he has, and he did that so well.
Okay, we'll come back at the end of the program to pay tributes to him, but I'd like us to begin with more serious issues. That's more global issues, national issues, and what happened at the Constitutional Council. The decisions taken at the Constitutional Council, will you say they were a marked departure from what we have been experiencing in the past? Barrister Ndango.
Yeah, of course, from the convening of the electorate and for candidates to file in their documents to compete, there will naturally be disputes originating from the compilation of documents, and the law has given that given the Constitutional Council the opportunity to rule on all this. From the cases, we realized that there was a slight departure from what used to be, like when it comes to sociological composition of the list for candidates, and the decision that was handed, particularly with regards to Ngokutunja South, it was very surprising because it departed from the 2003 decision that was rendered concerning Douala 1. Notwithstanding, the decisions have been rendered, and being an auxiliary of justice, I cannot comment.
You were there as an actor, and would you say that, Barrister Baka, you were a keen observer of the activities and the action of the Constitutional Council? What I, as a person, observed this time was that there was no systematic rejection of files for lack of procedure. We didn't find that this time around, because in the past, especially when the Supreme Court was handling cases, they talk always about lack of procedure, and most cases were thrown out. Is it that the lawyers have become, or the counsels of the petitioners have become more careful, or that they are respecting procedures now?
I think I want to think that the petitioners and their counsel have become very meticulous in their filings, their petitions, because in the past we saw situations where petitioners took some pertinent points lightly, whereby you saw cases where petitioners, instead of signing, those who were signing for them were lawyers and all of that. So I think with time, lawyers have learned to correct those mistakes, and petitioners too have learned to correct those mistakes. And secondly, I think that the Constitutional Council, which is the structure that initially was supposed to be handling those petitions
is taking up its responsibilities because the structure has been put in place, so it wants to send out a message that we are here to do some work. So I think that that's why we are experiencing a difference.
What would you say has been the difference between the Constitutional Council and the Supreme Court sitting in as the Constitutional Council?
Yeah, the difference is very clear. The difference is that the Supreme Court was put in the shoes of some other person. The Supreme Court was sitting in place of the Constitutional Council, and the magistrates of the Supreme Court had no mandate. But the magistrates of the Constitutional Council now have a mandate. They have a mandate that they have to be there. They cannot just be thrown out. They cannot be sacked as long as they are there as members of the Constitutional Council. And we think that
does that impact on the decisions that they make?
It surely impacts, because we realize from these sessions that the Constitutional Council is gradually taking its place and asserting its independence with regards to electoral petitions. We see that in the days of the Supreme Court, there was no that independence was not there, because you are doing a case with the fear that it can be transferred, it can be thrown out tomorrow. But the Constitutional Council, the members know I have a mandate. If I have to be there for 9 years, I'll be here for 9 years, no matter what happens. So I'm judged by my conscience. So they take their decisions.
Yes, I think that we should also take into consideration the fact that we have an electoral code. In the past, the Constitutional Council had to grapple with several laws at that time. It was a bit complicated. The Supreme Court. Now we have an electoral code that has everything in it, and so you can pick up the document and you're able to touch and then read and come out with what you want to do, how you want to file your case and all of that. And the second thing I want to say is that we should also know that the Supreme Court was did not, as Barrister Tar said, was not actually, it wasn't there. That was not its initial
primary responsibility.
So it was just helping. I've stated that in substance, there is not much difference, Joe. There's not much difference. The only difference is that the laws, we have a court now, and then this Constitutional Council has been able to learn from a few mistakes of the Supreme Court and can pass judgments that we can find interesting today. Notwithstanding, there are some errors that I didn't appreciate, some decisions that I personally didn't appreciate. That I could have appreciated. That I appreciated what the Supreme Court did. So
maybe the day you be a magistrate, you might look at it differently. But let me see this. We refer to it as the Constitutional Council. Is it a court or it's a council? Can it be referred to as a court, the Constitutional Council?
I think, Joel, we should give it its name. It's a council, and that's why the composition of it, that there are people, members of that council that are not originally magistrates. And so once you talk about a court, you should be thinking about the training, the procedure of training magistrates and all of that. So we give it the name that has been ascribed to it from the law, which is the council, because it has people of different backgrounds that come to look at specifically issues that are within the Constitution that cannot handle issues of ordinary law courts. So it's not a court, it's a council.
Okay. You wanted to add something?
It's a jurisdiction.
Okay,
it's a special jurisdiction.
A special jurisdiction, but not a court.
Of course, it's not a court, but they rule like courts. The rule like court, there are decisions.
Can you say the Constitutional Court, or can you say,
you can say the normal parlance, or you can say Constitutional Court. It's a Constitutional Court. It's a court that rules on constitutional issues. So it's called a Constitutional Court. You can say that. But now those who man those courts, all of them, those who man the court, all of them are not magistrates. So we call it a council, preferably.
Okay. But the other ones can go. From what your explanation. Okay, let me turn. The two of you have monopolized the talking, so let me turn to the other co-panelists. What intrigued you about the process, the pre-electoral dispute, Eugene?
No, it's bits of what have already been said. the fact that it seems that the legal professionals are now getting it right. The cases are not, in the past it was a question of procedural issues in the submissions or in the petitions. This time we see a marked improvement. But what I take from that is that processes like these are very useful in building trust in the electoral system and in the rest of the process from now till the results are proclaimed. And I think compared to previous years, we come up with a sense that we're all getting it, whether it's from those who are there to interpret the law or to those who participate in the process. But it still leaves a lot to the imagination of whether people can come out of this thinking that there is a clear sense that the rule of law was seen in application, whether people see the independence of the judicial institutions, that everyone felt that you could have a fair hearing, whether it's in front of a court or a council or a tribunal or whatever. And that's one of the things that have been lacking in this country for a long time. I think that's how it plays out in the public mentality. The public is not so interested in the legal technicalities of what's going on, but it's whether they feel that after observing this, they can trust that system and have trust in the electoral system and the results, and that the system is set up to work in the interest of the people and not in the interest of a privileged few.
Okay. Honorable Fobichinda, your party came out with some of the wins, if I might call them that way, from the council. Does that give you a sense of ownership, that belonging, that the council can now, or has given you a fair hearing because you felt cheated and they have reinstated you within your rights?
Let me permit me to correct your questions. Yes, we had a few wins, but we also had a few losses. So, but before I get to the question, I want to draw your attention to something that apparently has missed the attention of many. Those who have been drawing up the list in the Northwest and Southwest particularly have faced a particular problem of having members for their list. I mean, it's a problem where they give you a name today, tomorrow the person is desisting because, he was under threat, or his life, or his family was threatened.
Yeah, that's
so
obvious.
The list, let me come. It's very, very important. Now, you get to a point where you can barely get in a list because all your major players are running away from the list. And why I'm saying this is that even a political party, a very prominent political party, argued that in the Supreme Court and the Constitutional Council, saying, look, we've had difficulties having members on our list. But the Constitutional Council was deaf to it. It didn't give them the right. It is something that will happen again because the problems of insecurity have not been solved. So from now through the electoral period to the post-electoral contest, we are going to be seeing phenomena. This phenomenon will be repeating itself.
Okay. So
please, it's something that I think the Constitutional Council should address itself to. It did not address itself to it this time.
But the law doesn't say anything.
It doesn't. But when you sit as a court or a council, there can be mitigating circumstances. The law says this, but you are sitting there not as a machine. You can interpret mitigating circumstances, and you are a judge of the last resort. Mm-hmm. Therefore, you have powers of interpretation. At least in our Anglo-Saxon tradition, you do. I'm not so sure it happens in the other tradition. Okay. That's what we are pleading for. Okay. That we have exceptional circumstances on the floor, in the field, and exceptional circumstances require exceptional dexterity.
Okay, but if you take exceptional circumstances or mitigating circumstances, then you will be diverting from the law, because the law doesn't have the law doesn't consider that, even though the magistrate might be able to use his own.
The law never considered that there will be a war. that you're going for elections during a war. So, all right, so either you decide to stop the war, I mean, have peace before you go for elections, or you go for elections now taking into account the specificity, as the word is very randomly used, is of a war situation.
Okay, but Barrister Baka, yes, I'll get you, Barrister.
Just to respond to Honorable, mitigation is not created by the judge. Mitigation is found in the law. So before a judge comes out with mitigation in his judgment, especially in the criminal case, we have it already in the law.
We're not in criminal cases, unfortunately.
So that's why I just want to say that mitigation is not created in a vacuum. The judge does not create mitigation. The judge interprets the law as he has it, as it is in front of him. So the Constitutional Council, it is not in its place when we are in a pre-electoral litigation to come and start talking about the circumstances that do not favor elections. That's not what it's called upon to do. It's called upon to interpret whether what is in front of him, the list, has what the law says is supposed to have.
Okay. So. Now, you were in the court as a defense counsel for the Social Democratic Front, but you listened to other things. Why did the council entertain petitions from the UPC in spite of the fact that it had a problem of leadership?
To seize the Constitutional Council, of course, the law has given conditions to seize the Constitutional Council, and if those who seize the Constitutional Council met those conditions, they had the power to do. They had the right to do that, and we should understand that the Constitutional Council actually ruled on the petitions and authorizing some sections or factions of the UPC to go for the elections. We should understand too that this goes a long way to tell Cameroonians that an administrator does not appoint a secretary general in a political party with regards to the status of that political party. We understand at one moment the Minister of Territorial Administration had to recognize a secretary general who is not the one that was voted by the political party. Of course, the one that was elected by the people was now invested or actually sponsored a list, and the one that was appointed by the Minister of Territorial Administration could sponsor some. Now the question before the Constitutional Council is who is supposed to sponsor those lists. So is it the Secretary General that is appointed or the Secretary General that is elected with regards to the statutes of the political party? Of course, the Constitutional Council gave a stamp of approval to the list that is sponsored by the elected Secretary General of the UPC. If that was not done, that would have been, they would be making a lot of injustice.
No,
particularly
that was done. Let's leave, don't interpret further. Does that now mean that the elected Secretary General of the UPC is the rightful leader of that party?
That's what we're saying. That is a stamp of approval.
But the Constitutional Council did not come out with that ruling.
Because it was not asked them. If you ask them that which one is the rightful Secretary General of the party, maybe they would have told you. But now by giving a stamp of approval to their list means that that is the Secretary General of that political party, and that the decision of the minister to appoint one was unconstitutional.
Okay. Did the court, did the council take a decision or a landmark decision, according to you, that marked you?
I'm not sure. I mean, there is nothing that came out of this process that would turn the tide on the electoral process. Again, from the perspective of the citizens on my attitude towards the electoral process and the courts and the institutions of the country. What we saw, again, if you take the examples of the things that have been raised, the court didn't position itself in to serve justice. It strictly applied the law, and legality doesn't always equate justice. And at this level, you would expect to see more tendency towards the service of justice than the strict legality of the law. And unfortunately, that's what we saw. That doesn't build trust, because if the laws are bad, the court is going to strictly apply those laws.
But the problem here, you apply them before you change them. Because if you don't apply them, then you're moving towards anarchy.
Well, ask the lawyers, and they will probably tell you that whatever legal tradition you take, the ultimate goal is to serve justice, and the law is only a means to that. And that is why the decisions that the judges take are weighed based on the merits of the law, but also on the arguments and what Honorable has referred to as the mitigating circumstances. It's a combination of factors, including the law, that leads to a decision. But if you insist that it's only the law that has to be applied, like I say, in a system with unjust law, there are going to be a lot of unjust decisions.
Okay. Honorable, he says there wasn't any landmark decision according to him, but there was this issue about a candidate from Douala, a nationality problem. Was that not key in trying to handle some of these problems that we have in the country?
Well, I mean...
Dual nationality?
Cameroon does not recognize dual nationality, that you know. And if you can prove that he's holding another nationality, it excludes him from Cameroonian nationality. And that was what the court upheld.
Even
the court upheld that he couldn't be on the list.
Born and bred in Cameroon?
Yeah. Well, the court had proof that he had enjoyed another nationality. You understand? I don't have the facts of the case, but because I'm one of those who believe that dual nationality should be acquired to any Cameroonian who wants it. It's better for the country. But on this particular issue, the court upheld the decision to scrap him from the list, and I thought they respected the law.
Okay.
I just wanted to reply my young man who was talking about mitigating circumstances being written into the law. Every judge, whether you know that or not, is bound by two things. He's bound by the law and his conscience. His conscience is not written in the law. Thank you.
Even though the conscience should not violate the law.
It is not written in the law.
It
is his. And what influences the conscience?
It should not violate the law.
No,
we're going to say that you're guided by your conscience and the law. And it does not mean that your conscience should violate the law.
Your conscience does not violate the law.
I think
you get to a point, like in the British tradition that we know, where the judges, because of their conscience and because of a laxity in the law, will make the law.
Yeah, of course they do make laws. Magistrates do make laws.
Those are jurisprudence.
Yes. Exactly.
Yeah. Barrister Baka.
I want to come back. Barrister Taz answered the issue of the judge on mitigation that the Honorable
raised. Yeah,
but he has answered it. But I want to talk about the issue of landmark. I'll come back to it. It's very, very important because that case you cited, to me, it's a landmark case because it had to do with a member of the Central Committee of the party in power that opens up the debate for what we are talking about, the double nationality, that a resolution was passed at the just ended national dialogue, which is going to help this country to look into it and then come out and put the law in place to amend the 1968 law on nationality to be able to give the opportunity of people like him who have something to offer to this country to come in and offer it.
Okay. So what did you learn from the pre-electoral disputes?
I learned so many things from the pre-electoral disputes, of course, starting with the case of nationality and the time frame and the reasons why people are calling for the amendment of the electoral code. We realized that the time for people to file petitions, 48 hours, is too short. I doubt if somebody from Yagua or somebody from far north, I don't know, can get to Yaoundé, prepare a petition, and annex proofs and file. It becomes very cumbersome.
Does the law not permit petitioners to use electronic means?
The law does not permit electronic means. The law instead permits the postal means. If you file it through the post, it might get to Yaoundé when somebody's mandate has ended. So it might get to Yaoundé after the elections, and then it will just be thrown out. They cannot listen to it again. I think such should be looked into. The issue of nationality as raised in the session, in the Constitutional Council, was very paramount, and we came out with a landmark decision, and that is the decision of that council. You cannot make an appeal against. And a candidate is on a list who is not a Cameroonian. The question now is, when is somebody considered not a Cameroonian? And they opened the debate because in the civil...
I don't want us to go into the details. Just, you've cited that.
What I'm saying is that there are so many Cameroonians still moving with Cameroonian passports who are not Cameroonians. The candidate in question...
It's important what he's saying.
The candidate in question was still having an electoral card. The consequences is that after this decision, ELECAM should withdraw that electoral card, the national identity card, and the Cameroonian passport. That's what the authorities of Cameroon should do, because that is the highest jurisdiction that has come out with a judgment to say that this person is no more a Cameroonian. We don't know how he succeeded to get.
Thank you for the advice. The people who are supposed to do that will do that.
I think there's an important case that we should look at. That case.
We are not in another case.
Well, not a case, but another decision of the Constitutional Council that is very important. That talks about the sociological composition of a list. The aspect of there's a case that had to do with Ngokitunja, right?
Ngokitunja South,
where it has been said the Constitutional Council has reversed a formal decision whereby interpretation that was given this time around some sort of promotes tribalism. Whereby they, instead of looking at the sociological composition of a list in terms of people from different backgrounds that reside within the constituency, they went into to looking at the tribal and lineages and all of that. It becomes a bit problematic and complicated. I think that in the future, the Constitutional Council
is there not jurisprudence in terms of sociological composition?
What we are saying is that the court departed from its jurisprudence.
Yes, they had been.
And now throwing people in confusion. Yes. I don't know what will happen in 2025.
Okay.
Because now
let's wait for that time to come, and then we'll handle
I think the issue which can be placed otherwise, that the definition of sociological content, it should be better defined.
Exactly. And it should be defined by the court now.
Yes.
Let the court now define it.
No, the legislator, because you've refused the court taking judgment.
Yes.
Let the legislature define for you what is the sociological component of a list.
Exactly.
All right?
Okay. Thank you, gentlemen. Let's move on to our next issue now, which has to do with the extraordinary session of Parliament that held in Yaoundé and that ended on Friday.
The members of the 9th Legislature meeting for the last time in plenary are applauded for their remarkable efforts to push forth the decentralization process in Cameroon. For House Speaker Honorable Kavege Jibril, it is now time to support the policy which intends to boost socio-economic and cultural developments as well as consolidate peace.
Que les Camerounaises et les Camerounais se donnent désormais la main.
Cameroonians should henceforth work hand in glove and put an end to all the vague desires of destabilization. Contributing each at their level in the work of nation building, our ambition is to lead Cameroon to its emergence by 2035. Let us therefore develop the emergence culture.
La culture de l'émergence.
The General Code of Regional and Local Authorities adopted and awaiting enactment into law by the head of states is lauded by many.
Cameroonians have been expecting a bill that would have come to break the ice and to maybe clear the way for violence to stop in our country.
This task will be developing our local village and so on in economic, social and cultural way.
To others, the special status for the Northwest and Southwest regions remains unclear.
It's actually silent on the Anglophone space. It is silent on the ability to legislate at the regional level.
As the people's representatives end their mandates, they leave with fond memories.
It was interesting that I was the youngest governor, then I came to become the oldest man in the house. To me, that was wonderful that at 75 I was being made a member of the House of Assembly.
While some go to campaign for the 10th legislature, they are exhorted to stay mature and to accept the verdict of the polls.
Okay, let's move on to the code on decentralization. But before we get to that, Honorable Fobi, it's been a wonderful time for you in Parliament, close to 7 years, even more.
More like 6, but it's like you say, it's been a wonderful time, fantastic time. Challenges, a lot of challenges. But remember that we're in the 4th year of a war. And that war, we've tried the best to try to solve it at the level of the Assembly. And we've taken a few beatings, we must be said. All the development projects we sent to the Northwest, Southwest, the most we had even areas that were executed to 2-3% or not executed at all. So you can imagine that, yes, it was challenging, but it was difficult.
Difficult not only for you as members of Parliament, but of the opposition more.
Which opposition? We are of the opposition.
I mean, yeah.
It was more difficult for, it's always been difficult for the opposition, having to get a sitting government to negotiate for peace within its own country, which at first they've never wanted to. And as I'm talking to you, they are still not in a mentality to negotiate for peace. You understand? It is not easy for the opposition. And but the battle must go on. The battle must go on the floor of Parliament.
When you say the government did not negotiate for peace, and we have you are just coming from an extraordinary session of Parliament, is that not part of what was decided at the major national dialogue? And to be able to have people sit down and be able to have you, the lawmakers, come up with laws that can help in solving the problem?
It's an excellent question you're asking there, Joe. So let me take you to the source of it. At the beginning of this strife, this war, Mr. Biya took 2 positions. First, he said the form of the state is not negotiable. And he said secondly, on va les écraser, which meant he opted for a military solution. As I'm talking to you right now, those 2 are still valid. 1, he called for the national dialogue. National dialogue, nobody can tell you up to this day what is the content that came out of that dialogue. Anglophones got in on their side.
Were you part of the national dialogue?
I'm coming. I was part of it. That's why I'm disappointed in it. Anglophones went in, we sat in, and we gave a list of things that we wanted. It was a list of our wishes. It binds Biya in nothing. Mr. B, we're sending supplications to him. This is what we want. He had to choose what he wants and when he wants it. What is the result? The result is that he sent a budget to us in the Assembly, which apparently we had agreed, we had discussed in the national dialogue, 3,500 billion was what the Northwest and Southwest needed for rebuilding. A bill has come the first year, 2020, 120 million for 4 regions, Northwest, Southwest, Extreme North, and the East. It's a far cry from the 350 billion, which would have expected if you took the 3,500 and divided by 10 years.
But you work depending on the means available, right?
Depending on the means available, but above all on the political will available, which is not. Let me just show you. I continue on that point. You come to the point of special status, which we agreed in that.
We will come to that shortly.
But then again, I'm building a case for lack of political will. At the time of special status, nobody again knew what the content was. In the SDF, we got back and said, let's help you define it. Take Quebec as an example. The long and short of it is that what has come to Parliament, which we'll be talking about under the Code for Decentralization, is a glorified deliberative organ, whereas what we were hoping was a legislative organ for Northwest and Southwest, for legislative organs.
Okay.
It's a big cry.
Okay.
Just take one more step.
Just
the law on languages, the law on languages that came to us, it is a glorification of the status quo of what has existed up to now. Nothing in there changes the country toward a major step in bilingualism. No. So, where Mr. Biya started 2 years ago by his declaration, the form of the state is non-negotiable, that's where we are now, because the violence on in the streets, the army is still killing. So nothing has changed.
Okay. This is according to you, right?
Do you have facts to the contrary?
Yes. Just excuse me, others would answer.
Sure.
The Prime Minister sent people to the regions, and our trusted men of God came back and said the situation was improving. I don't know from where you're taking your own fact. Certainly, it has not stopped completely. But those who went to the field said things were improving. Now, I'll come back to
Did they tell you that they went with armored cars?
They did not go with any armored cars.
They didn't tell you that? I can give you the names of those who did.
No.
Okay.
You were not part of
to take the names.
No, because he wasn't one of them.
I refused. I was not part of them.
Yeah, but some of them are chicken-hearted. So
listen, it's not a personal issue.
No, it's not a personal issue. I want to pass on the floor. I'll come back to you.
Okay, please.
Yes. So when he says what he says, and we know that the major national dialogue took place, and this was what many people were clamoring for, and that recommendations were made. And top among the recommendations was to further the decentralization and give the Northwest and Southwest special status. And Parliament has been convened for an extraordinary session with something put in place in terms of a code on decentralization. How would you react to what he has said, given that you were part of the major national dialogue as well?
Well, Joe, I want to say that I'll say something with regard to what Honorable said. Honorable talked about the budget on rebuilding, and he's not comfortable with the fact that the amount put in place is less. Is that not a contradiction when you think that he's saying that the war is still ongoing? Why will you be talking about the rebuilding when the war is still ongoing?
My conclusion was that we start with the peace. We stop the killing. So you forgot my conclusion.
Yeah, just hold on. He would land. You will take back the floor if you want to.
The second point I want to say is that the problem we have here is that Anglophones got into the major national dialogue without contemplating a special status. So they were interested in having a federation, you know, and they later on came out with a special status, and so they're waiting to see what the content would be. The content now all depends on what the person given the special status contemplated with regard to decentralization, because we must understand that we are talking about decentralization, and when we talk decentralization, we know that there is a central government that devolves some powers to the local communities. Unless we want to change the structure, what we want to say in Cameroon, then we get into attacking the content of a special status or the decentralization code as it has come out. So to me, I think that the special status, but for what Honorable says with regard to deliberative powers of the organs of that special status, I don't think that something could have been expected different from deliberative, because we have the central government that gives out what it thinks it can give out in a decentralization.
Okay, what about the Executive Council, which exists only in the Northwest and Southwest?
The Executive Council,
which can take decisions that have to do with their respective regions.
No, the decisions the Executive Council take is decisions that emanate from the deliberative organs, right, of the special status. Yeah, so there's not. I just think that it's about the Executive Council is just about functioning. It has nothing special as compared
you wanted
to
something that had to do with legislation.
With regards to the regional council, whatsoever that is saying has been created, we still have the opinion that I'm still of the opinion that what has been given to Northwest and South is not what they were asking for, and even if they came out with something in the special status in a constitution,
the decentralization
code, this decentralization had failed some more than 20 years ago.
Because it did not have this code.
Because it did not have, it had failed. And if they are going back to it, just to pick up something from there, say, no, there was a special status. Just when I was looking at it, there was something there like a special status. And then you come and pick it up and you tell Cameroon, you don't even ask them, actually, this thing has caused us problem. There's a special status. How do we make good of this position? You go, you draft what you think that is good for them, and you tell them that this is, I'm giving you people a special status. I am of the opinion you should have allowed the people of Northwest, Southwest to define the content of their special status. Not for you to give
that
them.
not be excessive? When you say
that will no longer be.
Yes, that will no longer be
decentralized.
Yes, who even told you that this decentralization is what the Northwest man and the Southwest man was fighting for? That you are saying that that's no more decentralization. You should have even given them the opportunity. It's federalism. What?
What the key behind this is good governance, right?
Yes.
And the drive within the law until you change it.
The institutions that have been proposed now will not in any way foster the decentralization that I'm talking about. There is still a governor in Northwest and Southwest who is the supervisory authority.
No. When it comes into force. Okay.
I wanted
to react to what he said. There were two things. There were two basic fallacies which he made, which must be corrected, because they came out of his very mouth. The first thing he said was that Anglophones went into the major national dialogue unprepared and not knowing what they were going to expect.
No, that's
on that
not
score,
what
he
I
was
said.
right.
They didn't know about a special status. They didn't contemplate special status.
But it's in the Constitution. It's in the Constitution. Why didn't they contemplate it? You mean that they didn't know the Constitution? It's in the Constitution. Article 62 of the Constitution. Let me come, please. I'm coming. But he said something. I said two things. I said two things. First, that was a fact, what he said about they are going in unprepared. But he said something about the person giving away the special status. Nobody except the Anglophones can define the special status from themselves. They came into a republic of equal partners, into a federal of equal partners. Nobody can say, we give you special status. No.
Yeah.
It is within the law, right?
We can define it together. Okay. We sit down as partners and say, we define it together, but you don't give it.
Eugene
you don't give what you don't have. I'm sorry.
Eugene?
You see, and this is what is going to skew the debate a little, because we are timing the debate to the national dialogue. You cannot have this conversation without going back to 2017 to 2016.
Wow.
And so if you put that time frame into perspective, you find that a number of things are happening. One, we still have a prescriptive approach to resolving the problem.
Yeah.
In spite of the fact that I'd said here on this table that the only way you're going to move away from the current situation is a negotiated outcome. Even if this special status was a negotiated outcome, it would have a better chance
of survival,
of succeeding.
Yes.
The way we have arrived at it, it won't work.
Yeah.
Remember that there is deep lack of trust, and lack of trust not only among of the Anglophones towards the central government, but also of the central government towards the Anglophones. If you don't resolve that problem, and you can resolve that problem with methodologies and approaches, have a negotiated outcome. If people say that what they want is a special status, and this is what that special status means, have the courage for the interest of the country, which everyone claims to protect, to move with the people. Yeah. In a democracy, the only voice that matters is the voice of the people. Self-determination is not just about independence. It is about people feeling that they are charting their own course, that they are defining their own destiny, that what they have, whether it's good or bad, it's what they have chosen. It is that element of choice that is lacking in this process. It is the fact that people feel that their views, their opinions, their feelings, their anger has not been sufficiently considered in the process. It is really not a question about whether decentralization is good or bad. It's not a question about whether the current special status is good or bad. It's a question about whether or not the people who feel aggrieved see themselves in these processes. And to the best of my knowledge, at least from a personal perspective, that's not the case. And therefore, it's unlikely that we are going to move radically forward with whatever is on the table now.
There is this aspect. Okay, Teke has just come in. Let's give him 1 or 2 minutes.
Okay, Joe, quite a good number of reactions. We may not be able to take all, but let's begin with Ben Joseph, who says, with due respect, the decentralization code that's enshrined in the 1996 Constitution may not be the solution. And Ricky Reed say it's some kind of a disappointment. And Besem Eplikeyong says the program is good and he's still waiting to see the implementation of the decisions on the adopted in Parliament. And Chuanji Herbert say how I wish someone would tell us the truth. Calvin Cham said the special status per se is destined to bring hope, and we hope it the content will reflect the entire aspirations of the people concerned. And Tachi Roland says special status could bring hope if the administrators in the 2 English-speaking regions are replaced with elected representatives. And Prince Mutapeme Obesa says nothing will change. It's like a book which is voluminous but yet empty. Eno Manyi Samuel says grey and dark hair are ancient enemies that will never agree. And Donwy George says nothing much. There is a lot of bias, egoistic tendencies when it comes to implementation of laws in Cameroon. And Tumasang Joseph says,
okay, maybe we end with that.
With it appears the Emeritus Cardinal Tumi is already crying foul play, and the president has played a fast one on the Anglophones.
Okay, we have just a few minutes. So, what positive things are in the code that can help advance either the decentralization or local government or development forward? I'd like us to move that way, beginning with you, Honorable.
But before I do, let me say that we have fought against that bill. The good principle of legislation says that once you've fought and it's been voted, it goes into law. One of these days, we hope that Mr. Bia will be promulgating a law, or he'll be sending it back. We actually hope that he sends it back for a second reading. If he doesn't, and he promulgates it into law, at that point it becomes a law, and the legislator that I am has 2 choices: either to work to change it or to do with it. There are aspects of it which I think I could live with. For the 8 regions, the regional authorities are a good thing. The 8 Francophone regions is something new to them. For the Anglophone regions, we have already executed legislative power and independent power. It is difficult to step back into a deliberative organ. I hope that the Anglophones will find a way to work around that. Okay. It will be a hitch.
Okay.
The independent conciliator, if they can extend his mission to include the control of the government services, it will be necessary, because for now his jurisdiction is only on the council and regional executive. It must include the government services. Okay. I could continue, but you're running out of time.
Yes.
Yes, I'll let it.
Barrister Baka.
Barrister Baka.
Thank you. I wanted to come to the aspect of independent conciliator. It's a very important component of that code. It's very important for the special status of Northwest. If you take time to look at it, it actually helps in solving some of the problems that might come up with regard to influencing of the powers of the executive council and all of that. And then the second thing, I want us to be very clear, Joe. This we are within the context of decentralization. Now, if you follow the African Union Charter on decentralization, local governance, and local development, this decentralization code actually follows the prescriptions of that act. I think if we didn't have this crisis, this code should have been embraced without serious problems, because the only issue, Joe, is that if the Anglophones have a guarantee of the sustenance and the protection of their heritage, which to me, I think, if we had something that had to do with modification of our constitution to give a kind of power alternation for the Anglophones and Francophones in this country to be able to sustain this achievement, I think that we wouldn't have any problem. To me,
okay.
in terms of decentralization,
the positive, just a quick one, the positive
thing. The positive thing, the scrapping of the position of the government delegate, a super mayor that was appointed by the executive to supervise elected officials in the various regions and OBN at the level of the urban councils. And I will quickly say that with regards to the special status and the bill, I still hold the opinion that
we're talking about the positive aspects.
The people should have been asked.
No, we're talking about the positive aspects now. Eugene?
No, I think you're asking a question that kind of tries to corner one, because I'm struggling. I'm really struggling.
If you're struggling, then there's no need to close the program.
I'm going to explain why I'm struggling.
Because you've not read the law.
No,
the bill rather, which has been voted.
I'm not going into a code and looking at specific articles. I'm looking at the package and asking myself whether it moves us forward. And the answer is in the negative. I cannot tell you that as a package. I can go there and pick scraping of government delegates. That doesn't move the needle at all.
Okay.
Now, as long as you have...
Our time is up. Our time is up. Okay. So we'll have to end here. Thank you so much for coming and for being with us. Certainly we'll be talking about that in other programs, so this program next week when we come. It's been unfortunate. We couldn't get people who could, especially people of the CPDM who saw reason in that law. We will certainly be coming back to that subsequently. Thank you so much for being with us on the program this midday. We look forward to being with you again same time next week. Until when we meet again, have a nice time on CRTV and stay with us if you can. Tamtam Weekend is coming up shortly. Good day.